Welcome back to Let's Talk Title with Emerald Coast Title Services. I'm your host and president, Dion Moniz. We have our Director of Operations and co-host, Ashley Bowen. Welcome back. We are at episode 16. This is part 4.
I don't know how you keep up with that.
Of our, me neither. Part 4 of our series on contracts. We think it'll be a 5-part series with the final episode next month being on the addenda between the two contracts. But today, we're going to get through the remainder of the main contract. And so last time we discussed inspection periods and closing costs. And so today, what are we going to talk about, Ashley?
Today, we are going to talk about defaults, dispute resolution, and then the real estate standards.
Yep. So starting at paragraph 13 in FARBAR, there's a whole section on escrow agent, and there's a similar section in CRSP, but let's go ahead and kind of address briefly what that takes care of.
The escrow agent, or the closing agent would be us, always. You wrote that on page 1 of the contract.
That's the most important part of the contract.
Emerald Coast Title Services.
Emerald Coast Title Services as the escrow agent.
And what our job is as escrow agent is to hold the funds and then disperse the funds. It talks in paragraph 13 of the FARBAR contract, it talks about the funds being collected funds. That means funds that have cleared our escrow account, which is why a wire transfer is required for your final cash to close, because we don't have time for a check to clear our account like we do with earnest money. It's okay if you give us earnest money because it's going to usually sit in our account for 10 days or more.
Right.
But collected funds means cash in our bank account that we can disperse on. And this paragraph 13 also talks about whenever there's conflicting demands for a deposit, what our job is to do. And it tells us that we have 2 options. We can either hold the funds in escrow until a resolution has been met, or we can deposit them in the clerk of court. It also says that you're allowed to charge attorney fees for your time in doing all of that, filing the interpleader.
Yep. Yeah, so what these sections set out in both FARBAR and CRSP is, as escrow agent, we have an ethical obligation to make sure there's good money ready to close, which gets into the collected funds part, which is why you always you hear us preach about wiring us the money, because even certified checks these days, or cashier's checks,
they're not automatically cleared in our account.
Because they're counterfeited so much now, so they don't automatically clear like they used to. So wire's always best. And we'll get into the whole wire fraud issue at a different episode. But yeah, always call us to verify wiring instructions and send us the money that way. So the other part of the ethical obligation is if there's ever a dispute as the EMD, we're obligated to hold the money and do one of 2 things with it. Either let the parties resolve it in court, or we can do what's called an interpleader action, which basically we're filing a complaint as escrow agents saying, hey, court, these 2 parties can't agree on what to do with the money.
These guys are being jerks.
They're being jerks. Here's the money. So the money goes to the court to hold, and then the parties have to respond and litigate it amongst themselves, in which case...
We're like wiping our hands.
Yeah, then we step out. But to your point, Ashley, we get to collect attorney's fees for that interpleader. It's in both sections on these contracts. And those generally run around $1,200 by the time you draft the complaint, get it served on everyone, pay the filing fee. And so if you're arguing over a $5,000 EMD, suddenly that just got reduced by $1,200 because the parties couldn't agree and we had to file an interpleader. And so I'll use that a lot. If the parties are arguing, I'll try to step in as a neutral party and say, this is how I think the contract reads. I'm a real estate lawyer. This is what I think would happen in court. If you can't agree, and if we have to file an interpleader, this is what's going to happen.
And usually that works.
Usually it does work, exactly.
If there's an EMD dispute, a lot of times that email that Dion sends out, everybody kind of magically comes to an agreement.
9 times out of 10, it helps for the parties to hear from a real estate attorney as to what the contract really says and what each party's rights are. I always recommend they get independent counsel because we're a neutral party, but I'll send the same message to both sides saying, here's what I think. And yeah, 9 times out of 10, they can get it worked out, because once you get to the point of litigating and or doing the interpleader, then only the lawyers are making the money, and then it's just whittling down the EMD. So So anyway, that's section 13 on FARBAR, and I can't remember the number under CRSP, but it's almost the same. And so when you hear us talking about interpleader and ethical obligations and all that good stuff, that's where it's set forth in the contracts. All right, so we're going to skip now to the dispute resolution sections, which is a very important part from a lawyer standpoint. There's a big difference between FARBAR and CRSP on how these play out, especially when it comes to prevailing party attorney's fees. So under both contracts, they both say that if there's a dispute as to EMD, or anything for that matter, but it's primarily over the EMD, then the parties have 10 days to try to resolve it. And then if they can't get it resolved, they can do mediation. And the mediation gets split, the mediation costs get split by both parties. Now, I always get the question, well, what happens if the other side won't agree to mediation, in which case you just move on to step 2. You can't force the other side to mediation. It just says the parties can mediate. So that's where the difference starts. In FARBAR, after mediation, you can do a civil lawsuit. Under CRSP, you're bound to do binding arbitration. You don't get to do a lawsuit in civil court. So that's one big difference.
Can you explain what binding arbitration is?
Yeah, so essentially it's almost like a trial, but it's an arbitrator, and typically they're lawyers. But the parties kind of put on a mini trial in front of an arbitrator, and that arbitrator gets to decide, and it becomes binding. And then what you have to do is you have to take the arbitration award and do a fancy filing with the court to make it an actual judgment or an order that's enforceable in court. But ultimately, it's a binding decision by a third-party arbitrator. And under CRSP for the arbitration, it again says that both parties have to split the fees. And the last time I did an arbitration, the other side barely even did anything, and it was still at $10,000 in arbitration fees and attorney's fees for my client to pay. So it can get really expensive. So again, if you're battling over a $5,000 or $10,000 A&D, you're going to spend $10,000 on arbitration fees. It doesn't make any sense because under CRSP, there is not an attorney fee provision. So even if you go through all this and you win, you don't get your attorney's fees back. In Florida, the only way you get your attorney's fees awarded as a prevailing party if it's in the statute or if it's in the contract. And so when it comes to contract law and real estate closings, there are no statutes. It's all governed by the contracts. So if you don't have an attorney fee provision in the contract, you don't get your attorney's fees if you win. With some minor exceptions, there's a proposal for settlement and all that we can go over in a different episode, but that's a trick you can try to play. But overall, what's important is to know that the contract itself does not have a fee clause. FARBAR does. So mediation doesn't work, you file a lawsuit, prevailing party does get an award of attorney's fees under the FARBAR contract. So that's a huge advantage. Because a lot of times, if I'm not escrow agent and I'm actually an attorney representing one of the sides, I can say, hey, you're in default, and if we have to sue you, you're going to have to pay your attorney and you're going to have to pay me back after we win. And so a lot of times that creates enough incentive for the party on the wrong to just resolve it.
Big difference in these two contracts.
Yeah. So now, yeah, if you're fighting over a $10,000 EMD and you have to pay your attorney $5,000 to $10,000 and you lose and you have to pay me $5,000 to $10,000, then suddenly you just spent a whole lot of money, fighting over $10,000. So anyway, big difference between the two.
It is.
So something to keep in mind.
It's Dion's favorite section of the contract.
One of my favorite sections. Although I always say, like I said earlier, the only parties that prevail in litigation are the attorneys. So I'm always interested in trying to get the parties to resolve it and not get into litigation. Because for us, a closed file is a good file. I don't want it to go to litigation. And even if I have a party approach me outside of a closing that we're handling, I'll still try to talk them into getting it resolved because it just doesn't make any sense.
Waste a lot of time and a lot of money.
Yeah, because a lawsuit can take a year or two, depending on how much it's litigated. So that's a lot of time and headache and expense to worry about.
Certainly is.
All right, Ashley, your turn.
Okay. All right. Now, the standards is the next section of the FARBAR contract. It's section 18. It's the last section of the contract. I think that's 19. Oh, addenda is 19. Yeah.
Yep. Section 18 in FARBAR
is pretty much the last. This entire paragraph, basically the standards are the terms. It's like the definitions.
This is the 4 pages essentially that CRSP cut out.
CRSP cut that out. So there is a section of paragraph 18 that talks about a 1031 exchange, and a section that talks about FERPTA and explains it right there. The CRSP contract doesn't have those, but it does have them in the addenda that you attach to the contract. And so you just have to be a little bit, you have to kind of know what you're looking for to attach it in the CRSP contract, and you don't really have to worry about it in FARBAR.
Yeah, so FARBAR already has it built in, whereas on CRSP, you've got to be, the onus is on the agent to make sure the proper addenda are included, whereas it's already in FARBAR. So way back when CRSP decided they were going to make it easier,
they made it harder.
They made it harder on the agents, yeah. It is shorter, and it appears to read a little bit better, but it's not as protective for both parties. So, and this is one of the reasons.
So the first part of Section 18 talks about title evidence, restrictions, easements, and limitations. It basically says the things that my commitment is going to say. It says that you've got to have like ingress and egress to the property, which is like access to the property. It says that the commitment that we provide and the title insurance that we provide at the end of the day, it tells you what all it's going to accept on the title insurance policy. And then the title examination is the next section, where it tells us that the buyer has 5 days after receipt of the title commitment. Both of these, I believe, have 5 days. Yeah, so 5 days after the receipt of the title commitment, the buyer has a chance to look it over, and if there are any defects in title, then they have to, in writing, tell the seller, hey, there's these issues that I need you to fix, and then the seller has to, at that time, start trying to fix what's wrong with title. Like, I've got one going on right now where we've got some federal IRS liens, and so that's title defect. It's attached to the property. And so the seller is working with the IRS to clear them up. And the contracts, both contracts, give you a cure period. It's 30 days for the seller to work on getting it cleared. If after the 30 days they haven't cleared it up, the buyer can either cancel the contract and get their EMD back, or they can extend the cure period to another 120 days until the seller can, I guess it just depends on how badly the buyer wants the property, if they're going to stick to it.
Right.
But that cure period, I think, is it's something that doesn't really get talked about a lot, but
it doesn't. It's very common in commercial transactions. It's everyone that I've handled on the commercial side, on either side of the fence, the buyer's counsel, as soon as they get that title commitment, they issue a title objection letter to the seller's counsel and say, all right, these are all the title issues you got to get cleared up. And then that triggers the cure period. That way, if the seller can't get it cured, then it opens up some remedies. So in here, it's in the contract, but the only way you trigger that cure period is to actually do a title objection letter, which most parties don't do on residential.
No.
So, because we had that come up last week or week before, seller was trying to get an automatic extension to cure the title defects, but there was not a title objection letter, so that language didn't kick in. And the buyer had to agree to give the extension. Otherwise, the buyer could say, you can't close with clear title. I'm out. Give me back my money. And they get the MD. Whereas if the title objection letter is done, the cure period's triggered, then that seller does get that time frame. So that's something to be mindful of.
Well, and it's important that you work with a title company who will give you the commitment and explain it to you if there are issues on it.
Right.
And then you have the chance to then, in writing, tell the seller, hey, you need to fix these things.
Right. Yeah, because we'll typically send it, and if y'all see something really weird, you'll draw attention to it. Otherwise, if it looks pretty clean, then
title looks good.
Yeah, good to go.
Mm-hmm.
So, yeah, that's an interesting section in FARBAR. Again, it's not in CRSP. I can't remember if it's in one of the writers or not. We'll discuss that next month.
The cure period, it's in there.
Okay.
It's just in the meat of the contract. Same little title section.
Yeah.
It's the same thing with the survey. If there's any encroachments or problems with the survey, then that also can kick in that title examination cure period. It says that you've got ingress and egress, you've got access to the property. This talks about, again, about the lease information if the property is
Yeah, this addresses estoppel letters. So 10 days before closing, the seller has to provide estoppel letters.
So not just a copy of the lease like was in the beginning part, but this is also the estoppel letter.
Yeah, this is the final estoppel where the tenants have to certify that they're not in default and all the rent's paid and all that good stuff.
Okay.
So yeah.
And then we have time. That is one of the main it's pretty big difference in the two contracts. So this is where it says that in FARBAR, the calendar days shall be used in computing time periods. And if a deadline falls on a weekend or national legal holiday, then it rolls over to the next business day at 5 p.m. And then CRSP is your business days.
5 p.m. on the business day.
Mm-hmm.
Yeah, it actually states
Every
5
deadline
p.m. Yeah.
Is 5 p.m. on business days.
And that goes back to our first part of this series where we were arguing over whether or not you have until 11:59 p.m. under FARBAR if it's not on a weekend or a holiday. And ultimately I said we need to use 5 p.m. just to be safe. But yeah, it's interesting how that's worded in FARBAR
and we had
versus
talked
CRSP.
about the way that time's computed in the two contracts before. And FARBAR, it's always like a strict deadline. And then in CRSP, it's the earlier of these two deadlines. I actually had one of our really good clients who sells a lot of real estate call me over the weekend and say, I never use CRSP because you guys told me not to, but it's a CRSP and I don't know what the deadline is. And so we had to kind of work it out. Like, okay, it's the earlier of these 2 days.
Yep. It's down with the calendar and a calculator or whatever. Yeah, exactly.
And then force majeure is different in each of these contracts as well. The FARBAR, force majeure is an act of God that keeps you from closing.
Right.
But the FARBAR actually includes the inability to obtain insurance, where CRSP doesn't have that language in it. So we may not have a hurricane hitting us, but there's a hurricane in the Gulf, you can't bind insurance. And so the FARBAR just added that little bit of language, which I think is good.
Automatic extension. Yeah, CRSP has language that says if it's due to circumstances outside the party's control, then it qualifies as a force majeure event. So you could argue that, hey, I can't get insurance because of this hurricane, it's not my fault. But
you could argue anything.
Backdoor clause. Backdoor clause is what we like to call that. So it's a little more black and white in FARBAR, a little more gray in CRSP, and lawyers love the gray, so something to keep in mind. But one last, because we're about out of time actually. So one other thing I wanted to address, or at least reference, is in the standards for FARBAR. There's a whole section on FERPTA, half a page, and we're going to do an episode on FERPTA after our contract series. Yeah. So it actually addresses what all needs to be done, whereas CRSP just says if FERPTA applies, the parties will comply with FERPTA. I mean, basically that's all it says.
What's FERPTA?
FARBAR gives a lot more guidance on that, but we'll do that in another episode. So I think that's going to do it for today.
Okay, so that means we're done with the contract.
We're done with the actual contract.
That only took us 4 months.
That's right.
And then we'll get addenda next time.
Yep. Next episode is addenda, so stay tuned for that. And again, we're always looking for cool topics that you want to hear about. So send us a message or
drop it
whatever,
right here.
Email, drop it here. Follow us. Smash that like button. All that good stuff.
That like button.
And so we'll see you next month on addenda. Sayonara.